So, Kentucky Constitution 21. Ready for 15 minutes of a ton of fun? Right? So, I don't know. I actually appreciate listening to Crash Course, even though I've read a lot of the material that he has, just for like reinforcing that knowledge. You don't just osmosis. People think that because once they said it, then it's learned. No, that's not how ideas work. Just because you said the idea doesn't mean that the idea is learned. First, people have to agree with it, then it has to be retained, and then that's got to be used, right? So, Kentucky government politics and public policy. We're just talking about where I left off, this very dense piece about all the different ways that the Constitution has been amended and how it's been interpreted. So, the first 26 sections of Kentucky's Constitution constitutes the Bill of Rights. And so we had started on that, and that's actually how Kentucky has more freedoms than what America provides, because you have a right to kill yourself with, no no added punishments. That's in the Kentucky Constitution. You have a right to a violent revolution. You have a right to revoke a charter of a corporation. You got a lot of freedoms. That's more so than the Bill of Rights in the America's Constitution. So the language of these sections was taken largely from the Pennsylvania Constitution of 1790, but borrowed some verbiage from the Declaration of Independence and the Virginia Declaration of Rights in 1776. Framers of the Third Constitution and the current Constitution added one section each. In the Third Constitution was Section 2, which denies absolute and arbitrary power, and the current Constitution, Section 25, which forbids slavery. The framers of the Third Constitution added subsections to Sections 1, authorizing the legislature to enact laws to prevent persons from carrying concealed weapons. So in the Third Constitution, they add that section to Section 1, so now you can't carry concealed weapons. So the Section 2 and Section 25, which are kind of opposite. Section 2 was put in there to keep slavery, but Section 29 or 25 was there to say that slavery is absolutely illegal. So this is 1891. Section 2 and Section 25 is added, but out of the 26 sections of the Bill of Rights, 24 of them come straight out of the Pennsylvania Constitution of 1790. And so, the people of what people were thinking in the Pennsylvania Constitution was very important. The framers of the Third Constitution added subsections to Section 1, authorizing the legislature to enact laws to prevent persons from carrying concealed weapons. So we have the right to carry arms, but just not concealing it. And 11, authorizing the legislature to enact a general change of venue law. And then in 1988, voters ratified a legislative addition to Section 19, in effect prohibiting strip mining under broad form deeds unless such mining is specifically agreed to by the parties to the deed. The Kentucky Constitution's Bill of Rights guarantees all the freedoms guaranteed by the U.S. Constitution's Bill of Rights, and in some instances expands those freedoms. For example, the Kentucky Supreme Court has found in Section 5, which guarantees the right of religious freedom, together with Section 189, which prohibits the use of public school money to support religious schools, which is an interesting statute, especially here in Bible Belt, Kentucky, right? So maybe it has it in this Robert Ireland book, but it's saying Section 189 says you can't have no public money for schools. School money not to be used for church, sectarian, or denominational school. No portion of any fund or tax now existing or that may hereafter be raised or levied for educational purposes shall be appropriated to or used by or in aid of any church, sectarian, or denominational school. So, yeah, I think actually University of the Cumberland's got in trouble for getting some money from Frankfurt because of Section 189. So they're saying because of freedom of religion is in Section 5, because of the right of religion in the separation of church and state statute in the Constitution. So Section 189 combined with Section 5, combined with the U.S. Constitution, all those together prohibits the use. It actually has a higher wall separating church and state. So there's a bigger, thicker wall for Kentucky of having a wall between church and state. You can't finance any schools. You can't give textbooks to a Christian organization or Muslim or Satanic or any other religion out there, Mormonism or Buddhism or Islam. So in Fannin v. Williams, 655 SW2D 480, 1983, the court held unconstitutional a statute that authorized the state librarian to supply textbooks to children in parochial schools, a church-state relationship that had been upheld by the U.S. Supreme Court in a case concerning the First Amendment to the U.S. Constitution. In 1992, the Kentucky Supreme Court cited language in Section 1 that referred to inalienable rights: the right of enjoying their lives in liberty, the right of seeking and pursuing their happiness, to find a right to privacy that was violated by a state statute that punished consensual, deviant sexual intercourse with another person of the same sex. It's not deviant. Deviant's D-E-V-I-A-N-T. This is deviate. D-E-V-I-A-T-E. So they punish consensual, deviate sexual intercourse with another person of the same sex. So they were saying that the Supreme Court cited language in Section 1 saying that people has a right to enjoy their life in liberty. They have a right to seek their own happiness. Therefore, there is a right to privacy. And even though a right to privacy isn't explicitly in the U.S. Constitution, Chief Justice Louis Brandeis, which came out of Louisville, Kentucky, he says that there is the right to privacy, with a combination between the right of search and seizure to be safe in one person's papers and effects. So there is a right to privacy. There's an implied right to privacy because of several of the other freedoms that were guaranteed by the Bill of Rights. So it's kind of ironic, in 1992, the Supreme Court will actually find language that says you can't get sodomy. That's what they're talking about. So there is sodomy laws on the books. So two men could not have butt sex, right? They could not. One person could not put their penis in the other man's butthole. But if there was a woman, if the man was a woman, right, and there was a man and a woman, the woman could have her butthole penetrated. So it's not about penetrating an anus. It's not about putting, you know, a penis in the colon. They had nothing to do with being natural, not natural. It just had to do with being homophobic. And so since the law wasn't equally being distributed between gay folks and straight folks, therefore they had to knock it down, because there's, you know, there's a right to privacy. They said there's an inherent right to privacy, so they can't get that. But there's also sort of the privileges and immunities and the due process and the you know, what's good for one state is good for the other. So like you have to have, all the laws have to be equal, right? No arbitrary absolute power over lives, liberty, and property of free men. So the equal application of the sodomy laws, why it was shut down, but also because of the privacy, the right to privacy. So 6 years before this decision, the United States Supreme Court had upheld a similar state statute that was challenged under the federal constitution in Bowers v. Hardwick, 478 U.S. 186 in 1986. So Bowers v. Hardwick, B-O-W-E-R-S v. Hardwick. The decision was not overruled by the court until 2003 in Lawrence v. Texas, 539 U.S. 558. The Kentucky Supreme Court also found in Section 1 a natural right to pursue a legitimate business or profession, which was violated by Kentucky's compulsory medical malpractice insurance statute. So by making doctors carry medical malpractice insurance, that is illegal, because they're saying that in Section 1 there's a natural right to pursue a legitimate business or profession. So you have a right to become a doctor without having to become insured in order to do it. Well, that's sort of like car insurance, and that's like health insurance. So they're sitting there trying to say that medical malpractice insurance cannot be mandatory, it cannot be mandated, but here we are mandated to carry auto insurance. We're being mandated to carry health insurance. And in 1939, or before in the 1930s, FDR ordered gold illegal. So if you own gold, you had to sell it to the government so they could build up their gold base. So, you know, the mandatory things, like that's what happened to the freedoms. They say we have a freedom to live our lives and liberties how we want. Now we can't own any gold. You know, we're supposed to be able to pursue our own happiness how we want to, but no butt sex of the same sex. You know, you can't have no butt sex at all. And so, 6 years before the decision, the U.S. Supreme Court upheld a state statute that was challenged under the federal Constitution in Bowers v. Hardwick, and a decision that was not overruled by that court until 2003. So they said that they upheld a similar state statute. They've been saying that there's a right to privacy in Kentucky, but they're not saying that there's a right to privacy nationally. So by having the Bill of Rights that Kentucky has, we're seeing the right to privacy sort of, there's a bubble, there's a space for a right to privacy to exist greater in Kentucky's court systems compared to America's court systems. So the Kentucky Supreme Court has also found in Section 1 a natural right to pursue a legitimate business or profession. So that's, you know, that's more a right to privacy, right to not be mandated to do something. Because I want to start a business, because I want to be a doctor, you have no right to force me to get insurance. Because I want to, I guess automobile isn't becoming a doctor and health insurance isn't becoming a doctor. So it's like, if I want to become a lawyer, then that means I have to get legal insurance. Well, if I'm trying to become something, I have to get insurance in order to become it. It could be a sort of a tax on it. But it also seems like they're getting away from some shit too. Medical malpractice insurance. That sounds, you know, if something goes down, that's bad. Insurance, everybody's got insurance, so that way everybody would be covered. It'd be cool. But I mean, it would be horrible to go down on something not having insurance and then, you know, basically being fucked over because you didn't do some tiny little thing right or wrong. The framers of the Third Constitution added Section 2 to the Bill of Rights as an attempt to prevent future legislative majority from emancipating Kentucky slaves without compensation to slave owners. So Section 2 of Kentucky's Constitution is fascinating. More recently, non-slave owning property owners have found the section's language, which is absolute and arbitrary power over the lives, liberty, and property of free men exists nowhere in a republic, not even in the largest majority, to be a more effective weapon against certain regulations of the economy than the United States Constitution. Thus, the Kentucky Supreme Court used Section 2 to invalidate Kentucky's milk marketing law. So I think it's Kroger was going to sell milk below cost in order to drive everybody else selling milk out of business. But see, the milk marketing law, I'm not sure if that's bad or good, because if you sold milk at $1 a gallon, you would get more people into Kroger to buy their milk. I don't know. I don't see that as being totally a bad thing, but they want to prevent monopolies and unfair practices, and they was able to use Section 2 to invalidate Kentucky's milk marketing law. And so it prohibited retailers from selling milk below cost. As an effort to prevent monopolies and unfair practices in the sale of milk and milk products. So the Supreme Court used Section 2 to invalidate milk marketing law. So they invalidated it, so they actually stopped it. So that means they allowed monopolies they could sell milk however cheap they wanted to sell it. So they try to stop it, but then they use absolute and arbitrary power of the lives, liberty, and property of free men exists nowhere in a republic. So the corporation was able to point that out as saying the government isn't allowed to tell us how to run our business, when actually that very much is what a democracy is about. The government offers the charter, gives the corporate charters out there, and if the government doesn't like you undercutting and getting all the small milk farmers out of business, you know, maybe it's something like that, if that's what their reasons was, they could do that. They're allowed to do that. But these are like changing constitutions, so these are like amendments, you know. This is not just passing a law, but it's, well, this is passing a law, but the Supreme Court is using the Bill of Rights in order to invalidate it. So it's kind of showing how the Bill of Rights in Kentucky is used. The Kentucky Supreme Court has ruled that Section 3 of the Bill of Rights, which declares in part that all men, when they form a social compact, are equal, together with Sections 1, 2, and 59, embraces the Equal Protection Clause of the 14th Amendment to the U.S. Constitution. So the Equal Protection Clause, that's what I was trying to say about the sodomy laws from before. So the Equal Protection Clause of the 14th Amendment to the United States and might provide greater protection of individual liberties than the federal equivalent. The Kentucky Supreme Court has generally embraced a generous view of Section 8's guarantee of freedom of speech and press. For example, see Ashland Publishing Company versus Asbury, 1980. We'll come up, actually, I want to see what Section 59 is.